All right, we are live and on the record.
That's probably the clerk calling me back.
Okay, good morning, everyone. This is Commonwealth versus Norris. I'm just going to call the case number. It's 2020J0203. And would you please both identify yourselves for the record?
Paul Lynn, Assistant District Attorney for the Commonwealth.
Jeff Harris for Kevin Norris.
Thank you very much. And I'm sure you both know, but I'm Gabrielle Wolahojan. So thank you for making yourselves available to have a hearing this morning on, I've got the single justice petition for Mr. Norris for a emergency stay of, it's not really a petition, but we've assigned it to the petition side of the docket. It's an emergency motion under Rule 6 for a stay of execution of sentence. I have a couple questions about it in the first instance that I thought it was easier to have a hearing on than to, that I just thought it was easiest to have a hearing on. The first one is, can anyone provide me with more detail about the cell phone possession that led to the violation of his and revocation of his parole?
I actually represented him on the revocation process. So there was a cell phone found in his car. We argued that it was unconstitutional search because they didn't really have any basis for going into his car and looking under the floor mat, but they found a cell phone. It was a smartphone. The contents of the cell phone were not at issue. The issue was him having it in the first place, and it was unauthorized, and he acknowledged that he shouldn't have it, and essentially pled, it's not pleading guilty, but, pled responsible for having it. Our argument was essentially that he shouldn't have it, but he should be re-paroled nonetheless, because it was a technical violation. It didn't suggest further criminality. There was no crime alleged around it.
He is eligible for parole in July. Is that correct?
He became eligible for parole, I think, in 2013.
No, but now he's eligible for reconsideration.
His next parole hearing is, so he was revoked in June or July of last year. So he should have another parole hearing coming up quite soon. He has a somewhat, he doesn't have the greatest relationship with the parole board these days, because there's been some litigation in Superior Court between him and the parole board around the ADA. And I know it shouldn't have any bearing on his eligibility for parole, but he has had a hard time in front of the parole board.
Mr. Lynn, can you help me with is there anything, because there was nothing in the papers about the cell phone. And I was curious about that, just the possession of the cell phone. Do you know anything about that? Can you add anything? It doesn't.
No, I can't. I just know that it was the grounds for his revocation.
Right.
Mr. Harris knows far more than that.
It's just the possession of the object and nothing more.
That's my understanding of it.
Yeah, like for instance, there was no allegation that there was pornography on it or something like that.
Right. So that's helpful to me. Now, Mr. Harris, I've read everything you both have submitted to me, including the transcripts of the hearings before Judge Giles. And I have to say that I have many of the same sort of reaction and thoughts that she expressed during those hearings. However, I also am wondering what the basis is for my authority here. There is no Rule 29 motion. Is that correct, Mr. Harris? I mean, I don't see how you could make it. It's way more than the 60 days after, right?
No, there's a Rule 30 motion.
Was there a Rule 30 motion, or was there, what I saw was a motion to modify sentence, or in the alternative to stay execution of the sentence?
Right, under Rule 30.
Okay, so and how would you would get a new trial?
Well, we were just trying to modify the sentence under 30A.
Okay, so what I see in CPCS versus Chief Justice of the Trial Court are three circumstances under which I now consider a motion to stay execution of sentence, and I'll just read them to you. They're on page, I don't know, I want to say 540. No, yeah, 541, but I don't think that's right. I think the Westlaw, which is you've moved under Rule 29, which is not the case we have here, has appealed the conviction or sentence and the appeal remains pending, which is not the circumstance we have here, or has moved for a new trial under Mass Rule of Criminal Procedure 30, which is not the situation we have here.
Well, I would point you to Judge Budd's decision in the single justice case of Commonwealth versus Daniel Tompkins, which is SJ 2020-0123.
I may have that one right here in front of me. Hold on. No, okay, I don't.
So in that decision, Justice Budd, weighing a Rule 30A motion, writes, the petition is denied on the grounds the defendant has an alternative remedy in the trial court, potentially a motion for stay execution of sentence pending resolution of his motion for new trial. And she cites to Charles.
But there was a pending motion for new trial?
A pending motion for new trial, i.e. a Rule 30 motion, but it was a 30A motion. It was a motion to modify the sentence.
Okay, so you're saying that you think that I have authority to stay execution of a sentence that you have sought to somehow modify pursuant to Rule 30A.
Right.
Okay. And the basis for that Rule 30A modification is the scientific research regarding, I'll just say, young adult brains.
Right. One of the two bases that we raised on the merits was that at some point he will be resentenced because there will be a recognition that emerging adults shouldn't be sentenced like adults. He was 18 when he committed the crime. He got a 25 to 40. It wasn't considered newly discovered evidence or newly available evidence in 2008, even 2015, but at this point, it certainly is.
And what would be the trial court's authority to revise that sentence now, given the procedural history in this case?
Well, the trial court would need to see that there's a reasonable likelihood that he will be resentenced.
No, assume what would be the judge's authority to modify, to allow that portion of the motion you filed down below that was Rule 30.
Well,
At this point, you know, you've got, given the whole procedural history that led up to it.
so the case that I cited is the Cruz case. Obviously, it's not binding authority, but this is how the law gets changed.
But don't you need, under Rule 30A, and maybe I'm mistaken about this, I could very well be mistaken about this. I thought under Rule 30A, you needed a circumstance that existed at the time of sentencing.
You mean like Rule 29? I think so people are filing Rule 30As for cruel and unusual punishment right now because.
Right, but you haven't done that.
No, I know, but it's a change. That wouldn't be something that existed at the time of the.
Okay, all right, so I wondered about that, but you don't make that argument. You don't make an argument that it's unconstitutional, whether, you know, as an Eighth Amendment matter or under the state constitution or due process, whatever, because to hold someone in confinement who's on a technical violation of parole, to hold them in confinement in these circumstances, you don't make that argument.
Not yet. I mean, I filed this motion on April 4th. So here we are. It's just that wasn't part of my initial motion, but that is
right.
Something
so
that may come.
Well, I mean, that feels to me like it would be something different than what's in front of me.
Oh, absolutely. That is different.
Okay.
Yeah, I'm not making that argument. I was just using that as an example of something that didn't exist at the time of the trial or at the time of the sentencing, that changes, that makes the sentence unconstitutional. The brain science is such a thing. I would say the conditions at the MTC are that's another issue.
Right. Now, since this has already been litigated in this case,
right,
how can I reach the conclusion that you have a reasonable possibility of success on that argument on appeal, it having already been litigated? Why would that succeed now?
It having what having already been litigated?
The issue about the subsequent development of science with respect to this sentence, as it might bear on this sentence.
Well, it hasn't been argued in front of a trial, in front of an appellate court.
Did you not appeal the previous denials of the new trial motions? I thought there had been many previous new trial motions.
Yeah, I would say the court on previous iterations, I was not the attorney on previous iterations of this, but the court in previous iterations of this may have been right to say that it was not yet newly discovered or newly available evidence because the science just wasn't there at that time. I would say that as the Cruz case showed.
Wasn't the last motion for new trial, wasn't the appeal on the last motion for new trial decided in something like 2017?
I think the motion was filed and argued in 2015.
Right, the appeal.
So that's what the record was at that time.
So you're saying there's something radically different in the science between 2015 or 17 and now?
Well, I think if you read Dr. Steinberg's testimony in the Cruz case, you will see that it's qualitatively different. And then at some point,
was that? When is the Cruz case? What year is the Cruz case?
I think it's 2016. I'd have to pull that up for you. 1 second.
It may be even later than that.
I'm sorry, it's 2018. Yeah. March 29th, 2018, court concludes that the hallmark characteristics of juveniles that make them less culpable also apply to 18-year-olds. So that, to me, is a qualitative change that will come to Massachusetts. He will be resentenced.
Okay, I think I've got your argument.
That's only, okay. That's only one of the two arguments on the merits, but okay.
No, I understand. Okay, Mr. Lynn?
Yes, what all of the science has been indicating that's come down over the last 2 decades is that juveniles, and in the Cruz case, Dr. Steinberg goes on to say that it should also apply to young adults, is that they should have a meaningful opportunity for release. And so it has almost always been applied to eligibility for parole. And here, Mr. Norris has been eligible for parole for over 10 years. So the Commonwealth's position is that he has his meaningful opportunity for release. So the new cases aren't going to affect that. My other arguments really go to the second issue. If you want to hear from defense counsel first on the second issue.
No, I'd like to know what you have to say about whether there's anything before me upon which I can act. This question about 30A versus a motion for new trial, because I'm puzzled by the language in Christie.
I would think that a viable, excuse me, a viable 30A motion would be the same as a viable 30B motion, because both of them would result in the defendant's release. But the Commonwealth's position is that the 30A motion isn't viable because he's already had review of his case based on this new science. The judge said in sentencing the defendant that he felt that this defendant was so young that he had a good opportunity to reform himself. And he took that into account. Granted, he didn't have the benefit of the more up-to-date science, but at least he had the idea, which is an ancient idea, it goes back over 100 years, that juveniles are less culpable than adults and should be treated accordingly.
So are you saying that the first part of Judge Giles' decision denying the motion to stay is incorrect? That part where she says, I don't think that I have the authority to do anything right now, to stay anything, because there's no, well, just the same language in Christie that I'm looking at. So you would say that you don't necessarily agree with that.
I'm not sure to the extent she said she had no authority, she may have been incorrect, but she certainly was in her discretion to say that this should be denied.
Sure, I understand that. She did that in the alternative. Okay, I'm sorry, I didn't mean to cut you off. So what do you want to say on the second argument?
This being the misrepresentation at the sentencing hearing?
Yes.
Yeah, I've read the police reports and reread the sentencing hearing, and it's not really a misrepresentation. The police report says that the defendant and this other man, who, if I'm reading the report right, was known only as Stan, were let into this apartment, and it said at that point the suspect, parentheses S, drew a knife. So it doesn't say that the defendant didn't pull a knife. It just isn't specific as to whether or not he did it or the other person did it or they both did it. And as for the return, the police report shows that the suspects took the victim's keys, and sometime later, there was a police report that the defendant had re-entered the apartment with the keys. The prosecutor was incorrect that he was arrested at that point. He got away, but he certainly did come back with the keys. So this is at the very worst a minor misrepresentation, and the judge made it very clear that his sentence was based on the crime, on the horrific nature of the crime. And remember, the defendant got a quaff on this previous armed robbery, which was broken down to larceny from the person. So clearly nobody thought of this as a crime that showed the defendant was irredeemably depraved.
So, can you address for me why I shouldn't be concerned about holding someone who served, he received a lengthy sentence, he's served a lengthy sentence, not the full sentence, but he spent a lot of time in jail. He apparently has done well while in jail. He apparently did well when he was out of jail, at least on the record in front of me. He's on this technical parole violation. I'm not saying they can't revoke his parole based on that. Of course they can, if that was a condition. I don't have the conditions, but I'm assuming there seems to be no challenge to that he was not allowed to have a cell phone. And given the current health circumstances and infection circumstances in the prison, why should I not be concerned about someone being held in these circumstances? I mean, it's, you know, I guess quasi-constitutionally, is someone who's on a technical parole violation, does this seem like a proportionate sentencing situation?
I think it would be inhuman not to be concerned in these circumstances. There's no question there's a problem. There's no question that he was revoked on a technical violation. The opinions of the courts that have come down, and they've been, I don't have one handy. If I can remember the name of the defendant who was ruled on, I will cite it. But the position of the courts so far has been that it is not a violation of the 8th Amendment or Article 26 to hold somebody. And as I believe I cited in my opposition, there's new evidence that was cited in the New York Times that asthma is not as bad a contributing factor to serious illness or death from COVID-19 than was originally feared. So you have in the defendant a man who is 47 years old, not of advanced age, who has a condition that is not as deadly as was feared.
Yeah, I'm just going to tell you, I'm not going to be that much swayed by something in the New York Times versus what's on the, you know, that the CDC is saying. So
true. Well, the CDC said that
we can't be acting as these kinds of medical authorities. We got to rely on.
I mean, it's true, but the court obviously has to consider the medical evidence before it, and it's not just some reporter saying, hey, I don't think it's as bad as it is. It's the Times reporting new medical data that updates what the CDC said about a month earlier. So there is some evidence that it's not as serious as the CDC initially feared.
So if the CDC still thinks it's as serious, if I went on the CDC website, for example, today, then that would be more reliable than something from a month ago from the New York Times?
It's hard to say. I haven't actually gone on the CDC website. I don't know if you would just find the information from 2 months ago, or whether you would find evidence to the contrary. To be fair, I haven't looked it up.
Right. Well, that seems to me like a tricky road to ask anybody to go down, is to weigh information coming from the Centers for Disease Control against something that was in a newspaper.
That's a fair point.
So, so if we just accept that asthma is whatever contributing factor the CDC says, then where do we end up? He's not above 60. There's a high rate of infection. He's there on a technical parole violation. He's served a lot of time. He's done well on release. He's done well in prison. How do we, help me with this?
I think that's Attorney Harris's argument to make.
Well, I mean, he has made the argument. I'm trying to hear, I guess what you're saying is the Commonwealth's position is, well, it's not that bad for him because he's 47.
Yes, that is our position. There have been several cases at the MTC. There have not been as many deaths as we initially feared, but it's, there's no question the defendant is in some danger. That's the big question is he in such danger that his sentence could be called cruel and unusual, or but without an underlying motion with a reasonable chance of success, I think that's the only grounds he would be entitled to release on, is it would be cruel and unusual under the circumstances.
Right. And Mr. Harris, this goes back to my question. That has not been raised in this case. And I have to tell you that I'm hesitant to, even in the guise of a Rule 6 motion where all I'm determining is some possibility of success on the merits of a claim, an appellate claim, it's really, I think, a bridge too far to ask me to rule on the possibility of success on the merits of a claim that hasn't been asserted yet.
I haven't asked you to rule on that claim, Your Honor.
Right. So, maybe that's, I can't tell you what to do, but maybe that's your best course. Because if I'm not looking at that and I'm looking at the more traditional Rule 6 analysis, and I can't take into account claims that haven't been asserted yet, it seems to me that you're in a tougher spot.
Yeah, frankly, Your Honor, I had hoped, and certainly not assumed, but had hoped that the DA's office in Suffolk County, with all of what they had been saying about decarceration and people who were in danger and all the support that DA Rollins had put behind the position of inmates going into the CPCS first trial court case, that it wouldn't get to this point and that it would be clear that this is an unjust situation and that Mr. Norris should simply agree to a resentencing because it's the right thing to do.
I know that you have made that. I've seen that. That's been going on, and I saw what happened with Judge Giles, and she added her voice to that chorus, and it didn't succeed. I have to admit I am puzzled by this myself, but I'm not a branch of the prosecutor's office.
Oh, I understand that. I certainly hope and trust that Mr. Lynn is considering that as well, because at least on the papers that I see, this looks like an unusual case to me.
I assure you, I went to Dan Conley when this case was before Judge Giles the first time. I have spoken to Chief Counsel Donna Padalano and David Lewis, who's in charge of our conviction integrity program. And the position of the office is that we're most concerned with cases which don't involve violent offenders, or where a violent offender is being denied his right to an opportunity for a parole hearing. The conclusion in this case is the defendant is a violent offender, albeit one who has tried to turn his life around in prison, and he's had several opportunities for release on parole. So we don't concede, we don't approve of resentencing. That's the position that the office has taken in this case. We have considered it. We certainly are not just simply digging in our heels and saying no. It's not the type of case that DA Rollins is interested in modifying the sentence on.
And Mr. Norris, not Norris, Mr.
Harris.
Harris, for Mr. Norris, Mr. Harris, your client has a scheduled parole hearing in July.
There is no scheduled parole hearing right now. I think parole hearings for quite a while have been put off. So they have not contacted me to schedule a parole hearing. He's not a lifer, so it's possible that they wouldn't have contacted me. I don't know. They probably would have contacted ADA Lynn, so he may be able to answer that question better than I.
If they've contacted anyone in this case, it would be ADA Bartoloni, who handles our general parole cases for non-lifers. So I have not spoken specifically to him, so I don't know.
It's probably worth having a discussion about that. And secondly, about maybe, and it would be your office that handles that hearing. Is that correct, Mr. Lynn?
That's correct, Your Honor.
And maybe it's worth having a discussion about what the Commonwealth's position would be at that hearing. I mean, for God's sakes, it's a cell phone.
Yeah, I certainly can discuss that too. That I think is more probable that the office would agree to that than the changing of the sentence. The office has been more forgiving in parole situations than it has been in the past.
I would ask you to do that. I mean, one of the reasons why I wanted to have a hearing was to find out, I thought this is ridiculous. There's got to be some backstory to this cell phone. I mean, what was on it, what he was using it for, et cetera, et cetera, et cetera. So I think that would be a good thing to do.
I would be happy to do that, Your Honor.
I would appreciate it. And in the meantime, I'm going to take the motion under advisement. You'll hear from me soon enough. I know, Mr. Harris, that you will probably file another motion, if I understand correctly, raising some constitutional issues. I don't think any decision I'm going to make here is going to affect that one way or the other. I'm certainly not going to weigh in on any of those. And I guess good luck to you all.
Thank you, Your Honor.
Thank you both. Thank you both.